Welcome to the deep dive. This conversation comes to you from us right here at Jonker Vorster Attorneys.
Hello.
Today, we're getting into something really fundamental. It underpins, well, so much of what we handle for clients, and honestly, it affects everyone.
Mhm.
We're talking about the absolute essentials for a legally sound agreement here in South Africa.
Yeah, think of it as the framework for making sure your deals stick, whether they're, personal things or big commercial transactions.
Exactly. And at Jonker Vorster, look, we see this every day, how vital it is for, well, everyone, individuals, businesses, to get these basics right.
It really is. It's not just about dodging problems later, though that's part of it. It's about giving you the confidence to actually engage.
Right.
So our mission today in this deep dive is really to pull out those core requirements. What makes a contract valid? We're drawing on our collective experience here at the firm.
So whether you're looking at a lease, maybe selling something, starting a business partnership, knowing this stuff is, well, it's your first defense, really. Okay, let's jump right in then. The absolute base layer, the foundation. It's getting everyone aligned, right? Consensus, that meeting of minds.
That's the starting point, consensus. And, it's interesting how the law looks at this. It's not just a nod. It's about agreeing on the uh, essential terms, the core stuff.
And there has to be an intention behind it. Like, you actually mean for this to be legally binding.
Precisely. That intention to create legal obligations is critical. Sometimes it's obvious from what's written, but it can also be inferred from how people act.
Like clicking I agree online. That counts.
That's a perfect example. That action signals your agreement, your consensus, even if you haven't, spoken a word.
So it's got to be clear. A proper offer and then a definite acceptance of that offer.
Exactly. Unequivocal acceptance. Like
And
when we draft an offer to purchase property for a client, it's specific. The seller's acceptance needs to match up. No ambiguity.
but this agreement, it has to be genuine, doesn't it? You can't be like tricked into it.
Absolutely not. That's a crucial overlay. The consensus must be freely given. It can't be tainted by, well, what the law calls negative influences.
Okay, like what kind of influences?
Things like misrepresentation, where someone tells you something false to get you to agree, or duress, being forced or threatened, or even undue influence, where someone abuses a position of power.
Right. So if any of that is involved, the agreement might not actually hold up.
Exactly. It undermines the idea that there was a real meeting of minds. It makes the contract potentially voidable.
Okay, that makes sense. You need a real voluntary yes. So assuming you have the genuine agreement, who actually has the power, legally speaking, to make that commitment? Let's talk capacity.
Right, contractual capacity. This is like a gatekeeper requirement. Not everyone can just enter into a binding contract.
What's the general rule then?
The general rule in South Africa is straightforward. If you're over 18, you typically have full contractual capacity. You can bind yourself.
But we know, especially dealing with families or younger entrepreneurs, it's not always that simple.
Precisely. There are important exceptions. Minors, those under 18, generally need their guardian's help or consent for most contracts to be fully binding.
Okay.
And then there are individuals who, maybe due to severe mental incapacity, just don't have the legal understanding needed.
Right.
And even for companies, juristic persons, their capacity is often defined by their founding documents. You need to check that they're acting within their powers.
So if someone doesn't have capacity, the contract might just fall apart.
It can certainly affect its enforceability, yes. It could
Yeah.
be void or voidable, depending on the circumstances.
Okay, so you need capable people genuinely agreeing. But what if they agree on something illegal?
Right.
I assume we can't draft a contract for that.
Chuckles slightly. No, definitely not. That brings us to legality. It's another non-negotiable pillar.
The agreement itself has to be lawful.
Correct. Its purpose, its terms, the outcome, it all has to be legal and not go against public policy.
And this isn't just about small print, is it? It's fundamental.
Absolutely. If a contract is for something inherently illegal, say selling prohibited drugs, it's void, just completely invalid from the
And
get-go.
courts won't even look at it.
They won't enforce it.
Yeah.
And public policy is broader. Sometimes a contract might be technically legal, but so grossly unfair or harmful to the public good that a court might refuse to enforce it on those grounds too.
Right. Okay. So we have capacity, consensus, legality. What's next? Does the agreement have to be doable?
Yes, exactly. That's the principle of possibility of performance.
Rena.
Meaning the things agreed upon must actually be possible to perform when the contract is made. Objectively possible.
So, if I promise to sell you my pet unicorn.
Right. Pet performance is objectively impossible. Unicorns, as far as we know, don't
Uh,
exist. That contract would be void because the core obligation can't be met from the start.
Okay, what if something becomes impossible later? Like my factory burns down after I agreed to supply goods.
Ah, that's a different situation. That's usually dealt with under rules about supervening impossibility or breach of contract. But for the contract to be validly formed initially, the performance needs to be possible at that moment.
Got it. Possible at the time of agreement. Now, assuming it's legal, possible, everyone's capable and agrees, the terms themselves need to be clear, yeah. We see this all the time. Vague agreements cause huge problems.
You've hit on a really crucial point: certainty. The terms need to be clear enough for everyone involved, including a court if it comes to that, to understand what the obligations are.
Why is vagueness such a killer for contracts?
Because if the terms are too uncertain, how can you say there was truly a meeting of minds on the specifics? How can a court enforce something if it's not clear what was actually promised? It can make the whole thing unenforceable.
So what kind of details are we talking about? The absolute must-haves for clarity.
Well, the essentialia, the
Hmm.
core elements. For a sale, you absolutely need clarity on what is being sold and for what price. For services, what exactly are the services and what's the payment? Timelines are often critical too. When is delivery due? When must the work be done? Lack of clarity here invites disputes.
So being specific in the contract document is key, which brings us to the documentation itself. Some deals are verbal, others need writing. Tell us about formalities.
Okay, so South African law is quite flexible in many ways. Lots of contracts can be verbal and still be perfectly binding, provided all those other elements, consensus, capacity, legality, etc., are there.
We often advise clients that their verbal agreement could be binding.
Yes, but then comes the but. While legally possible, proving a verbal contract's terms later if there's a disagreement, well, it can be incredibly difficult.
So writing is generally safer. But are there times when writing isn't just safer, it's actually required by law?
Yes, absolutely. There are specific types of contracts where the law insists on formalities for them to be valid at all.
Like what? What absolutely needs to be in writing?
The big one, as many property clients know, is the sale of land. Alienation of Land Acts require a written contract signed by the parties or their agents.
Okay, sale of land. Anything else common?
Yes, long-term leases of land, often those over 10 years. Also, suretyship agreements where you promise to cover someone else's debt if they default. Those generally need to be in writing and signed.
So the law puts these extra hurdles in place for certain significant agreements.
Essentially, yes. It's usually to ensure there's clear proof and to encourage parties to think carefully before entering into these quite serious commitments.
Makes sense. Okay, so those are the main pillars: consensus, capacity, legality, possibility, certainty, and formalities. Are there any other sort of background principles we should keep in mind, things that influence how contracts work?
Definitely. An important underlying concept is good faith bona fides. There's an expectation embedded in our law that parties should act honestly and fairly towards each other in their dealings.
Not just when signing, but throughout the contract.
Exactly. Throughout the life cycle of the contract. It's about upholding the spirit, not just trying to find loopholes in the wording.
And what if things aren't quite right at the start? Maybe someone wasn't entirely truthful, but it wasn't, say, outright duress.
That brings us to things like misrepresentation and mistake. If you were induced into a contract based on a false statement of fact by the other party, a material misrepresentation, the contract might be voidable. You might have the option to cancel it.
And mistake.
If both parties made a fundamental mistake about a key aspect of the contract, that could also potentially invalidate it. These areas can get complex and often lead to needing remedies like rescission or claiming damages.
So being upfront and clear from the beginning is not just good practice, it avoids a lot of potential legal trouble later.
Absolutely. Transparency prevents many disputes.
Okay, let's shift slightly and maybe tackle some common questions we get asked at Jonker Vorster. A big one is, can a verbal agreement actually be enforced in South Africa?
Yes. Let's be clear. Verbal agreements can be legally binding if they meet all the essential requirements we've discussed: consensus, capacity, legality, possibility, certainty.
But there's always a but, isn't there?
Chuckles, the big but is proof. Proving what was agreed upon verbally, sometimes months or years later when memories differ, it's tough. It often becomes a he said, she said situation. That's why we almost always recommend getting things in writing.
Right, the practical difficulty. What about capacity again? If you're dealing with someone and it becomes clear they maybe didn't understand the agreement due to, say, mental capacity issues, what happens then?
If a party truly lacked the required contractual capacity when the agreement was made, it seriously impacts enforceability. The contract might be voidable, meaning the person lacking capacity or their representative can choose to have it set aside.
Or even void entirely?
In some cases of severe incapacity, yes, it could be deemed void from the start. It really highlights why it's important sometimes to consider who you're contracting with.
And do you need a written contract for every little thing, like buying groceries? Obviously not, but where's the line?
No, definitely not for everything. Freedom of contract means you can agree verbally or even through conduct sometimes. The law doesn't demand writing for most everyday transactions. But again, for anything significant or where the terms are complex or where the law specifically requires it, like land sales, writing is highly advisable, if not essential. It provides clarity and evidence.
And just to hammer it home legality, why is that such a hard line?
Because our entire legal system is built on upholding the law. The courts simply cannot lend their power to enforce agreements that are illegal or fundamentally against public policy.
Mm.
It would undermine the rule of law. An illegal contract is essentially a non-starter legally.
Okay. And finally, what if the terms are just wishy-washy? Too vague?
If the essential terms are too uncertain, too vague, a court might find the contract unenforceable. Why? Because it suggests there wasn't a true meeting of minds on critical points. The court needs to be able to determine the party's obligations with reasonable clarity. If it can't enforce it.
So clarity isn't just helpful, it can be the difference between a valid contract and an unenforceable piece of paper.
Precisely.
Right. Okay. This has been incredibly helpful. Let's try and summarize. For everyone listening, what are those absolute core requirements we at Jonker Vorster Attorneys always check for in an agreement?
Okay, the 6 key things are: 1, genuine consensus, that meeting of minds. 2, contractual capacity, the parties must be legally able to contract. 3, legality, it must be lawful. 4, possibility performance must be possible at the time. 5, certainty the terms must be clear enough. And 6, formalities, any legally required writing or signatures must be present.
Get those right, and you're on solid ground.
Pretty much. Understanding these is your foundation for making sure agreements are enforceable and that your interests are protected.
And naturally, this is exactly what we specialize in here at Jonker Vorster Attorneys. This is our bread and butter.
Absolutely. Whether you need help drafting a really solid contract from scratch, or you need someone to look over an agreement someone else has given you, or, unfortunately, if you need help enforcing your rights when something's gone wrong.
That's what our team is here for. We provide that expert legal advice and support across all kinds of transactions, personal or business.
So please don't hesitate to reach out to us at Jonker Vorster Attorneys if you need that professional help.
Because getting the legal framework right from the start just provides that security and clarity you need. It really does underpin successful interactions and protects you down the line. Maybe next time we can dive into what happens when things actually go wrong.
That could be interesting. Breach of contract is a whole other area.
Food for thought. Thank you for joining us for this deep dive from Jonker Vorster Attorneys.